Your Honor, if it pleases the Court, my name is Moodley, initials J, and I am here today on behalf of my client Simon, a 15-year-old Aboriginal charged with one count of murder. As defense counsel for the accused, Your Honor, I submit that the evidence was obtained in contravention of statute, thus contravening public policy. The evidence carried substantial prejudicial value arising from gratuitous concurrence. Accordingly, the evidence should be excluded by way of Section 130 of the Queensland Evidence Act and the power vested in the court by Section 590 AA subsection 2 paragraph E of the Queensland Criminal Code. Public policy dictates that there is a public interest in the protection of individuals from unlawful and unfair treatment. Subsequently, the defense counsel asserts that the exclusion of the interview should be done due to multiple contraventions of the Police Powers and Regulations Act. Your Honor, we firstly turn to the most pressing issue, being the improper detention of my client for a period more than 8 hours, breaching Part 2, Division 3, Section 403, Subsection 2 of the PPRA. There is nothing to evidence an extension of the detention period within the said division. Section 403, Subsection 5, Paragraph 8 dictates that the detention period began upon the arrest of my client at 10 a.m. My client was subsequently held until 7:05 p.m., amounting to a total detention period of 9 hours and 5 minutes. This constitutes an immediate contravention of the section. Compounding this with Section 404, subsection 1, paragraph E, the officers failed to take into account my client's age, which should have warranted a shorter detention period. The next breach falls within Part 3, Division 3, Section 420, subsection 2, paragraph B of the PPRA, which stipulates that when questioning an Aboriginal or Torres Strait Islander person, the officer must arrange for legal aid representative to be present. Your Honor, there is no record of this phone call being made, which suggests that it was never made. In any reality, if the officers did make the phone call, it would be shown either in their dialogue, the phone company's dialogue, on the relevant telephone, or witness evidence from the legal service. The officer knew that Simon was of Aboriginal background, as he notified him that the Aboriginal or Torres Strait Islander legal aid would be specifically contacted. Therefore, the officer was in immediate breach of this section. Your Honor, the defense does acknowledge that our client is not of adult age, which is stipulated in Section 420, subsection 1, paragraph B. However, we do contend that this section should compound with Section 421, subsection 2, paragraph A, to create a more onerous duty on the officers. The subsequent section of 421 requires a child, Simon, to speak to his support person, his mother, prior to questioning. Subject to contrary evidence, the officers did not facilitate this right. It is likely at this point of the interview that the officers would have been aware of Simon's age due to the identity process necessary at the police station. Your Honor, the defense counsel now would like to turn your attention to Bunnings and Cross and the Crown and Island to assist the exercise of your judicial discretion against the recording. In accordance with the Crown and Island, this evidence was improperly obtained by way of unlawful acts and was obtained at too high of a price. Police must not think that they can behave like this towards citizens when still investigating a potential indictment. It is a matter of public policy to ensure that these practices are not encouraged, which can have the effect of producing wrongful convictions. Your Honor, may I direct the Court to the 5 factors enunciated by Justices Stephen and Aiken in Bunnings and Cross to inform Your Honor's decision to exercise your vested judicial discretion. Firstly, it is apparent that the conduct did not result from a genuine mistake. It was rather a deliberate breach of multiple sections and a willful non-compliance with the officer's obligations when performing responsibilities under Section 7, subsection 1 of the Police Powers and Regulation Act. The officers deliberately detained Simon for 3 hours while searching and then another 6 subsequent hours at the station, breaching their statutory obligations. There were many alternatives available to the officers. Additionally, they willingly failed to contact the legal services prior to the interview. Secondly, Your Honor, although the evidence was vital to the Crown's case, it was not perishable in nature. It is also not particularly cogent due to the factors such as gratuitous concurrence and the way in which the evidence was obtained. Thirdly, we contest that there was no evidence that the police's actions were a genuine response to pressing circumstances. They would rather appear to be cutting corners to ensure the indictment remained. They detained Simon for an extra period of time, which is not a pressing circumstance. The pressing issue here was rather to contact the legal aid before the interview to potentially guard against the cultural impacts faced. Fourthly, Your Honor, the defense counsel does acknowledge the gravity of the charge is severe and this may affect the evidence's inadmissibility. However, the conduct gave rise gave breach to 4 sections of the PPRA. The purpose of the PPRA is to prevent or regulate police conduct in terms of that evidence is obtained properly and to prevent the abuse of institutional power against individual members of the public. This is a textbook example of the exact kind of conduct the PPRA seeks to prevent. Your Honour, all factors present a strong case for you to exercise the court's discretion to exclude this evidence. Your Honour, the defence counsel would now like to turn your attention to the fairness discretion, otherwise known as the Christie discretion, which was accepted by the High Court in Lee and Hassler. Your Honour, in light of the Crown and Christie, although critical to the Crown's case, I ask that you exercise your judicial discretion in accordance with Section 130 of the Evidence Act to exclude the evidence on the grounds that it is highly prejudicial to the prospect of a fair trial to my client. Simon was a vulnerable witness in a stressful situation in which the PPRA is made to protect against. Your Honour, I believe our client was unfairly victimized by the acts of the officers and was likely to be so intimidated, being 15 years of age and in absence of a lawyer, as to be a disadvantaged witness due to the cultural impact of gratuitous concurrence. This issue of gratuitous concurrence is a phenomenon when an Aboriginal person is questioned by someone in a position of authority. They agree or affirm every proposition put forward to them by that person, even if they disagree with that or it is incorrect. This can prima facie make the evidence unreliable, less cogent, slightly probative, but highly prejudicial to the likes of a fair trial. Your Honour, we ask that on the basis of these 2 grounds you do exclude the evidence.